Good morning, class. You're welcome to today's lecture on entrepreneurship. In our last class, we were looking at the issues of business organizations, and we're looking at various business organizations that an entrepreneur may actually adopt in order to carry out his business objectives. We looked basically at the sole proprietorship, we looked at partnership, and we looked at companies. Today we'll be going on to look at a different or a fresh topic, which is fundamental legal principles in business law. We'll be looking at some of the legal principles that an entrepreneur needs to be conversant with while carrying out his business. Um, to this end, we'll be looking at things like the law of contracts, we'll be looking at things like the law of agency, we'll be looking at things like vicarious liability, we'll be looking at things like occupiers liability, we'll look at things like even patent and design. We'll look at some of these legal principles and we'll try and relate them to an entrepreneur. But for today's lecture, we'll be looking at the law of contract. I know all of you are conversant with the law of contract, being 200 level students, and so what we'll just be doing are things that, to a large extent, you're familiar with. Um, we'll just be looking at an overview of the law of contract in a very brief form. Now, what is a contract? Well, or what is the law of contract? The law of contract is a law that imposes a duty on persons to carry out their respective promises under a contract, and failing which a party who fails to comply with his obligations under a contract will be in breach of the contract. So basically, when we talk about the law of contract, we're talking about a law that holds parties to the obligations they have voluntarily taken by means of agreement. So what this law actually does is not to create a duty or duties for the parties. What the law of contract actually does is to hold parties to the duties they have created by themselves by means of agreement. So a contract is basically a voluntary arrangement in the sense that the duties taken by the parties to a contract are duties they themselves have created, they themselves have imposed on themselves. What the law comes in to do is to hold each party to his obligation. That means the obligation he has voluntarily taken under the contract. Therefore, when we're talking about the law of contract, we are looking at agreements which the law will enforce. We're not looking at just any kind of agreement. We are looking at the agreements which the law will recognize and enforce. It's not all agreements that the law actually will enforce. As 200 level students, you should know that where a contract does not have consideration, the law would not enforce such a contract. Or where there is no intention for that contract to be legally binding, the law would not enforce such a contract. So it must be a contract which the law recognizes and the law actually enforces. So that's basically what we're going to be looking at under the law contract. Now let's um, there are certain principles or characteristics that underlines the law of contract. Number one is that contracts are consensual in nature, means that they are based on agreements. Uh, as I did say, the duties taken up by the parties are not duties imposed by law. They are duties that parties have imposed on themselves, and that duty only becomes binding because the party to whom or upon whom that duty has been imposed upon has agreed to it in advance. So it is consensual in nature. It's not something that is imposed by law. Number two is that contract has an element of freedom in the sense that parties to a contract have the right to determine what the terms of that contract would be. So, to a large extent, parties can determine what obligations they want to assign to themselves. So, there is freedom in the concept of the law or in the law of contract. Number three is that the law of contract is determined by objective standards. Why we say objective? Objective means something that can be seen as against something that merely exists in the mind. When something exists in the mind is subjective. When something that can be seen or or experienced physically, that thing is an objective thing. So what we're saying is that in order to determine whether there is a contract, we need to look at what the expressions of the parties, either expressions in by means of words. We need to see either expressions by means of conduct. So we look at the conduct or the words of the parties to see whether there is an intention demonstrated by the parties to enter into a contract. So basically, we look at either the words or the conduct of the parties in order to determine whether there's a contract. So, where, for example, the words used or the conduct of the parties negates the existence of a contract, then it doesn't matter whether one of the parties feel there is a contract. If the words used and the conduct of the parties does not substantiate the fact that there is a contract, then no contract will be held to be in existence. Now let's go to the scope of the law of contract. Contract basically is born out of agreement. So the first stages of a contract will be the stages wherein parties actually come together to form an agreement. So the formation of that agreement or a contract or of an agreement is the um, starting point of a contractual relationship. Now, for an agreement which is recognized under the law to actually come into being, there must be offer, acceptance, consideration, and an intention to be legally binding. So once these four elements are present, then a contract has validly been formed. Then number two is that this particular contract may be expressed in different forms. So we are looking at the contract form. It may be expressed in different forms. It could be expressed in orally, it could be expressed in writing, it could be expressed in some formal document like under seal, or it could be expressed impliedly by conduct. Now, these are the various ways in which a contract could be expressed or formed, or the contract could be expressed. Now, it's important that when entering into a contract on any particular subject, it's important for you to determine what the position of the law is on the form that particular contract should take. For example, if you are going to transfer an interest in land, the property and conveyance law requires that that particular contract should be in writing. So if for the contract to be valid, you need to put that contract in writing. Or if you're going to appoint someone who is going to sign a deed on your behalf, that means you're going to appoint someone as an agent to sign a deed on your behalf. The law requires that such a person be appointed by deed. So a person who is going to sign a deed as an agent must be appointed by deed. So it's important that if when you are going into a contract on a particular subject, you should try and determine whether there is a law that stipulates that that particular contract must be entered into in a particular form. Otherwise, if there is no law stipulating that a contract should be entered into in a particular form, then a contract can be entered into in any way. So it could be entered into orally, it could be entered into writing, it could be entered into on the seal or impliedly. So as long as there is no prescription by law that a particular form should be followed, then any form is acceptable. Then number three, contracts often are built on a set of promises. Now, this set of promises is what we call contract terms. That means that there are promises exchanged between the parties that must be fulfilled, that each party looks to the other to fulfill in order to uh, satisfy the intention of entering into that particular contract. Now, these promises can be classified in various categories, and therefore the breach of these promises may not always do not always lead to the same legal consequence. Like, for example, if you take the sale of goods, there are um, certain terms that are called conditions, and there are certain terms that are called warranties. So a condition, once a condition or when a condition is breached, the party, the innocent party, the party who is not at fault, can bring that contract to an end. It has a right to repudiate the contract. But where the term is a warranty, which is a lesser term than a condition, that particular innocent party only has a right for to relieve in damages. That means he gets monetary compensation for the breach of that term. So you find out that terms have different classifications and consequences even under a law of contract. Then also there are terms that are implied by law. So when you have a document or maybe a document, you know, containing the in the terms or the promises of the parties, there may be certain promises or certain terms which may not, which the law implies into that document, which does not appear on the face of the document. So we actually call those terms implied terms. That means terms that are implied by law into a particular contract. It means that the parties need not agree on those particular terms. If once they are silent, it means that those terms apply into that particular contract. So once they are silent on those particular issues, they have not made provisions with relations to those issues, then those terms apply by virtue of law. There are even on certain terms that may apply even are implied into the contract and have the ability to override even the express terms, where the law does not give parties the right to exclude those terms. Then those terms, are implied and cannot be excluded by law. Then we move to exclusion of liability. Just as I did say, parties under a law, under the contract, can exclude liability for the breach of certain terms. So, if parties insert a clause within a contract stating that if certain terms of the contract or certain specific terms or all the terms of the contract is breached, they will bear no liability. That term will take effect as long as that term is actually contained in the document of the contract, and that contract has been delivered to the other party. It doesn't matter whether the other party has not read that particular term, as long as it is contained in the document and it has been delivered to the other party, it will take effect. So it means that when you have a document, it's essential that you read through that particular document to see whether there are exclusion clauses and to see what terms or what obligations the other party has excluded, from liability. Then we have terms or elements which may either render a contract void or voidable. Now, when we say contract is void, it means that the contract never existed. On on the other hand, when we say a contract is voidable, it means that a contract exists but can be brought to can be avoided or set aside by an innocent party, by his own election. That means an innocent party can choose to bring that contract to an end, or to set aside, sorry, could set aside that contract, by his voluntary action, by choice. Now, there are certain factors that could either make a contract void or voidable. Things like mistake, things like misrepresentation, things like duress, undue influence, incapacity, and even illegality. All these elements could operate in order to make a contract either void or voidable. Mistake makes it voidable, misrepresentation also. So all these things come in to either make a contract void or voidable. And the sixth one, sixth thing you need to in the scope of a law of contract is uh, discharge or termination, in the sense that a contract does not last forever. A contract at some point will come to an end. Now, there are various ways in which a contract may come to an end. It could come to an end by performance, it could come to an end by agreement, it could come to an end by breach, it could come to an end by frustration. So, these are some of the ways in which a contract might actually come to an end. And finally, we have the concept of remedies. So, where promises are broken, just as I did say that um, each that terms of a contract have there are very various classifications uh, for the certain for terms of a contract, and that based on that classification, the consequence of for the breach, is determined. So there are various remedies that are available where a particular term is breached. Sometimes you could have things like damages. Sometimes you could have remedies like specific performance, and sometimes injunction. Where there is a breach of a contract. With this, we come to the end of our lecture. If you have any question, please send your question by text message to 081 until our next lecture, I want you to encourage you to stay safe, and God bless you. Thank you.